In this video, I'm going to be explaining 5 ways to lose your restraining order hearing so that you can avoid them. My name is Veronica. I am a criminal defense and domestic violence restraining order attorney, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, we are going to be going through 5 ways to lose your restraining order hearing so that you can avoid them. Okay, the first way is to interrupt the other party or the judge. Now, some of us, myself included, actually pretty badly sometimes, are guilty of this, right? In conversation, we get too excited. We're thinking about what we're going to say instead of really listening. Yeah. And even more during arguments, right? If you're talking to your spouse, you guys are having a heated conversation, yeah, you might be tempted to interrupt. They're saying something and you're like, no, that's not true, and you want to get right in there. Okay, you cannot do that during a restraining order hearing. And I will take it a step further and say that if the judge or the other party start talking over you, even if it's your turn, stop talking. So with the judge, it's a sign of respect. Usually if the judge is interrupting you, they don't think that what you're saying is important, or they have a question about something that you have said. So it's really important to stop and truly listen to the judge. That's the person determining your fate here. And with the other party, now look, they shouldn't be interrupting you, right? I'm telling you don't interrupt them, but they might. And if they do, and you stop talking and simply zip it, the judge is very, very likely to notice. Lawyers, for all the fighting that we do in court, one rule that generally we do not break is we don't interrupt each other. And if you do, you're going to get in trouble with the judge. Each side gets a turn to speak. You can't speak over each other because there's a court reporter. And if you do, it's like nails on a chalkboard. So let the other side be nails on a chalkboard when they interrupt you. You don't be that ever. And again, it will be tempting when you're with your current spouse or partner and you guys are having an argument. You might be tempted to do this. But when it's an ex and you're pissed off because they filed this many times, at least partially BS restraining order against you, and you've been having a tough time, you're maybe sleeping in your car or something, and they have possession of the whole house and you're making the payments on it, yeah, you're going to be really upset. Maybe they've taken custody of the kids, your animal, but just make sure that you keep a level head and don't interrupt. Really not at all. Don't break this rule even a little bit, especially with the judge. If you interrupt the judge, it's over. Don't do it. Number 2, it's failing to understand what the case is really about, what anybody is actually trying to prove or disprove there. Now, as a domestic violence restraining order attorney, sometimes I end up sitting there all day long waiting for my case to be called, especially if my case is going to take longer. That means it goes last. So I watch people all the time stand up there and talk about how they did all the housework and the other party never did any. The other party cheated and they have brought evidence that the other party has been cheating. Whatever it may be, if it's not about domestic violence, you probably don't want to bring it in. Of course, there are some exceptions to this rule. If, you got caught cheating and then the other party abused you because of it, then yes, you probably should bring that in as the petitioner. But think about it. If you're the respondent and the other party is a huge B word, cheated on you, whatever, and you prove to the judge that that's true. The judge listens to you, even though it's not relevant. You prove to the judge that this is true. What are you really proving here? You're proving that you had motive and you were probably pretty angry to commit domestic violence. And that is the opposite of what you want to prove. So stay on point. That's really important. Stay on point here. This isn't about money. This isn't about who's the better spouse or who's the lousy spouse. It's not about any of that. It's just about domestic violence. Number 3 is failing to bring your evidence or witnesses. Now, if you are watching this YouTube video and you are doing your own research on how to win these, hopefully this wouldn't be you, but I see people do this all the time. People who say, oh, Your Honor, I do have a witness. I have my brother. He saw everything that happened, but I don't have him here today. You have to have your witnesses there. If you can't have your witnesses there and you are the respondent, you can continue the case one time. So get your brother or whoever your witness is get their schedule in advance or have them available to tell you what their schedule is, maybe by text or something. Make sure that you don't have evidence that you're leaving behind and you say, well, I have it, but it's at home. Or say, and some judges are okay with this, but in general, it's not a good idea. Some people will say, well, I have all the evidence. It's right here on my phone. Some judges will look at it, but many times they won't. And it's not that hard to simply take screenshots, print them out. If you have an iPhone and a Mac, use iMessage on your computer. You can save it all as a PDF. Don't include things that are not relevant. But if you have a text message that you believe is really important or a conversation for the judge to see because it disproves domestic violence, or if you're the petitioner proves domestic violence, then you want to make sure you have that there. I suggest printing it, bringing 3 copies. That is what attorneys do. It will look professional. And there's a chance if you bring it on your phone, the judge will say, sorry, I'm not going to look at it. If you have any kind of video or audio, then make sure that you have a way to show that to the judge. I do not suggest on your phone. If you absolutely have to do it from your phone though, make sure that you disable notifications. You don't want any kind of text coming up or anything embarrassing popping up when the judge is looking at your phone. So think about that in advance. But I suggest bringing a laptop, an HDMI cord, a USB stick that has all of the evidence that you intend to show. That's what attorneys generally will do because the court wants to keep copies of the exhibit sometimes. So what are you going to do? You're not going to leave your laptop. You leave your thumb drive there. The HDMI cord, and make sure you have a way to plug it into your computer. Mine, I think, needs like a little dongle to do so. But make sure that you have a way to plug it in. And usually you can use that with the court's AV system, but don't audio visual. The thing that plays the sounds and shows the videos. Basically the way that you can get it on the court's TV screens, and sometimes they have little screens for the judge, witnesses, etc. Those are not reliable. So I always plan to, in case something happens where that particular courtroom, maybe theirs is screwed up, I actually bring 2 laptops with me, one for me to use during the hearing, and then the other one is one that I can hand over to the judge if I need to, so that the judge can view my evidence. I want to make sure that if I have good evidence for my side, I absolutely show it to the judge. And by the way, if you are watching and researching this stuff, make sure that you click on the link in the description and get your free first class of my domestic violence restraining order course for people who are responding to these things. It is free. It's not on YouTube. You can't find it on YouTube. I do have a bunch of other videos about domestic violence restraining orders, but the course actually takes you from A to Z and how to win these things. So if you are interested in winning and you are planning to represent yourself, that is the only resource I've ever seen out there that is comprehensive and will actually teach you how to win. Now, obviously, if there's overwhelming evidence that you're guilty of domestic violence and the other side has a really skilled attorney that's definitely able to bring it in and is able to overcome the objections that I teach you, okay, maybe you're not going to win. But for most people, if you follow everything that's in the course, if some of what she is claiming or he is claiming is BS, and you guys are both representing yourselves, you will have a giant leg up and your chances of winning increase substantially. In fact, if you can execute it well, it could potentially be better than having your own attorney, because you can show the judge, look, I'm not just telling you that I'm a good, reliable person. I'm showing you, because most people who come into the courtroom and are representing themselves are a hot mess. So if you have everything together, you say, hey, not only do I have copies of my text messages printed out, but I have 3 copies here. I have one for the other side like I'm supposed to. I have one for myself, and I have one for you, Your Honor. You're going to come across as so credible. You're going to come across as a reliable, trustworthy person. And that is exactly what you want. That's exactly what you need in these restraining order hearings. So I highly encourage you have nothing to lose. Just take the first free class, find the link down below, and see if it's something that you think would help you. But if you're going to represent yourself, my course will help you. Anyway, let's get into number 4. Number 4 is getting angry or expressing frustration. Now, again, if you're watching this, you're trying to prepare as much as possible. Of course, you're not someone who thinks you're going to lose your temper, but I want you to visualize what this environment is going to be like. This is not your normal everyday debate here. This isn't something that you're fully detached from. The whole day is probably going to be stressful. So you need to make sure you're prepared for that. If you're prepared for it, then you can make sure that you're not going to be expressing anger or frustration. So you go through traffic, right, which is annoying. You're nervous. You park. That might be annoying or expensive. Most courthouses in Southern California, it's going to be. You have to go through security, which means that you have to line up. There are a bunch of other people there. So make sure you get there early, right? Otherwise you're sweating bullets, like looking at your watch and wondering what's taking people so long to take their belts off. Then you get up to security. They're not always nice. And especially if, you're not going to the courthouse every day and you accidentally leave your cell phone or some loose change in your pocket. The metal detector dings and now they're treating you like you're the biggest idiot in the world. That's frustrating. Then you have to find the courtroom. When you get there, the bailiff is shouting orders at people. Tensions are high. The vibes are not good. And then you see your ex that you haven't seen probably for a few weeks. And then that person is going to, in front of the judge in a whole courtroom full of people, not only air your dirty laundry, but say a whole bunch of stuff about you that at least some of which is probably not true. That's going to piss anyone off. Anyone's going to be at least frustrated in that situation. So learn some coping techniques. That's far outside of what I do for a living, but I'll just tell you that I just know that it's not me, it's not my case, but when I go in and I get pissed off at the other side, a witness who I think is lying, the judge sometimes, the clerks, don't even get me started with the clerks. The clerks are just trolls, basically. I mean, they are just, but what I tell myself is like, you just can't get annoyed. You have to have that self-control. You're just professional. You just have the facade, you turn it on, you don't turn it off until you leave. So I highly encourage you to really think about that, visualize everything, and visualize yourself getting through it without getting frustrated, without getting angry. Learn whatever techniques you need to. Make sure that if you're somebody who gets grouchy when you get hungry, that's me. Make sure you have a good breakfast, have whatever caffeine you need. Just take care of yourself really well. Give yourself what you need. And remember that you can do this. Number 5 is for people who have kids where custody is involved. Okay, so when you get your temporary restraining order, it probably says no visitation with your kids for several weeks, right, until the hearing. And you may think, okay, well, I just have to win this hearing. I'll do everything I can to try to win the hearing. And then, hopefully I win and then I'll have custody again. The thing is, of course, yes, you want to win the hearing. But if you lose the hearing, so let's say that the judge does find that there was domestic violence, you can still get custody of your kids. In California, there's a rule that if there's a finding of domestic violence by the judge, whether it was because there's a criminal case or because of one of these domestic violence restraining order hearings, and by the way, if kids are involved and custody is involved, that's probably the reason why they filed this restraining order in the first place. It's the dirtiest trick in the book, I think, out of any law I know in California, and it's a reason why I will not practice family law, because how all of that goes is so disgusting. Anyway, but if you're watching this and custody is involved, you know that already, right? What you need to do is understand that the best interest there's a rebuttable presumption that it's not in the best interest of the child for you to have custody if there's a finding of domestic violence. So what that means is that even if the judge finds that there was domestic violence, even if the judge issues a restraining order to protect your ex, that doesn't necessarily mean that you lose your kids, because rebuttable means that you can show evidence to the judge that the judge says, notwithstanding, like forget about the fact that I found that there was an allegation of domestic violence, that there was enough evidence presented to show that it was true. I still believe that this person, the respondent, is a good parent and that it is in the best interest of the children to be with him or her. So basically, what you want to make sure you do is all the reasons why you are a good parent. Maybe you take your kid to the park every Saturday and play catch for hours. You are the one who wakes your kid up, gets them dressed, gets them fed, gets them to school. All those reasons that you know that you're a good parent, any witnesses you have to show that you're a good parent, have them ready that day. A lot of people don't know that. Have them ready that day. Have all of that evidence ready to present to court. If there are pictures of you with the kid, videos of you with the kids, have all of that ready and be ready to present it to the court. It's really important to do that because there are many cases where the judge will find that, okay, maybe there was domestic violence. It's only the judge has to believe 51% versus 49% that there was domestic violence. So it might be pretty close, but that doesn't mean that you have to lose custody. And that may be the biggest thing that's on the line for you. Anyway, I hope that you found this video helpful. If you did, make sure you subscribe, ring the bell, but also if you did, go ahead and go get your free class. Click on the link below. You literally have nothing to lose, and you can get a taste of the entire course and see if you think that it's something that will help you. And if you're representing yourself, I mean, it will.